Okay, everybody. Good morning, and I guess good afternoon for those of you that are on the East Coast. My name's Steve Mitchell, and I am responsible for commercial lines here at Griffin Underwriting Services. And just want to thank you again for taking some time. I know that we're all in a bit of a crazy time right now, whether it's personal or with work, or as it turns out, how those two things are colliding. So, you know, I look forward to things getting back to some sense of normal. And I guess at the top here, I just want to say we appreciate you and what you're going through, and you as our customer, and we want to be here as much as we can for you. The reason we did this webinar, we are insurance professionals here at GUS. We're not bankers, we're not accountants, we're not attorneys, but we felt that this was valuable information to share out and to host. And we've got a great presenter today, Joshua Brittingham, and I'll introduce him in a second. But I guess at the top, just to satisfy the lawyers, you know, obviously this is information only. It's an overview. Hopefully you walk away with this with a better understanding of the paycheck protection provisions of the CARES Act. But if you or your agency or your clients need specific help on this for your specific unique situations, then obviously we would advise you to seek out the professionals for that. Just as an introduction to Joshua Brittingham is an attorney here in the Seattle area with Davis, Grimm, Payne, and Mara. He's passionate about small business. His parents are both small business owners. Before practicing law, he worked as a project manager and business analyst in the financial services industry. Is currently specializing in work around labor and employment. You know, his background and his approach around labor and employment matters from both a legal and a business perspective, with the goal of helping clients reach optimal results. And that's why he's doing this. I think he's doing this out of a place of you know, deep care for small business. He's a father of 3 young children, who I'm sure he's seeing a lot more of lately. You know, in his spare time, especially when we're not in quarantine, you know, he enjoys the activities with his family, coaching youth sports, other family activities like backpacking, golf. I miss golf right now. I'm just going to say it. So with that, bear with me as I work through the technology here, but I'm going to pass this off to Josh Brittingham. And thank you again, Josh, for being here. One just housekeeping issue. If you have questions during this webinar, please go ahead, and there should be a place on your screens to enter a question or chat. Either one is fine. I'll be watching those. If it makes sense to interject those questions during, we'll do that. But most likely we'll save those questions to the end, and I'll help Josh with that, or Chief Deanna, maybe he can moderate as well, and we'll try to get through as many of those as we can. We have about an hour together. We think we'll be able to squeeze the presentation in and the questions and answers in that hour, but we do have a little bit of flexibility on the back end if we need it. So with that, I'm going to pass this over to you, Josh.
All right, thank you, Steve. Can you hear me?
I can.
All right, so step 1, success. Well, thanks for that introduction. It is true, I am seeing my children much more, and it's mostly good, like 90% good, I would say. There's a number of silver linings with this difficult situation that we're all going through, and that is certainly one of them. Although I do miss the sports games and just generally getting out. All right, let's see if I can successfully do this here.
Yeah, I think I've passed it to you, so let me know if you have any issues there.
Yes, it looks like the ball's in my court, so let's see if we can do this. There I am. And where's my screen? There we go. So hopefully, if I'm doing this correctly, in a moment or two, everyone should be able to see the.
You're looking good.
The first slide.
Thanks, yep.
You guys gave me a reason to put on a tie from my home office, so I guess for that I thank you. Can you see the slides? Are they there yet?
Yep, we sure can. We sure can.
Okay, great. So let's get started. So like Steve said, I'm a labor and employment attorney out here in Seattle. I focus on helping businesses exclusively. I don't represent employees. I represent employers, and I handle labor union matters and employment matters. And it is true, I grew up with a small business family, and so I certainly understand the idea of a cash crunch for payroll during difficult times, and this is one that I think is unprecedented in everyone's lifetime. But there's some hope. There's some help. So what I'm here to talk about is the paycheck protection provisions of the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, as it's called. And see if I can advance this here. So my focus today is just going to be on the paycheck protection, or what we'll call PPP. You probably all heard of that term by now. That is a portion of the CARES Act. What's happening with these acts of Congress is passing various emergency measures. They're often omnibus bills, so they have a lot of other provisions. What I'm not covering is all of this, all the other things, Medicare payments, other provisions that don't really relate directly to employers. And I think it does make sense to save questions for the end, although maybe we can try to venture to do some along the way. I think with a group like this online, it's just a little difficult. Just to give us some perspective, we all know why we're here. It's the coronavirus and everything that's going on with the pandemic. But in terms of what Congress has done, just a little bit of a refresher course. Congress has passed 3 acts now. They passed a Coronavirus Preparedness and Response Act in March 6th. This is essentially injecting emergency funding into the economy. Then there was the FFCRA, the Families First Coronavirus Response Act. That has to do with paid sick leave and paid expanded FMLA leave for employers, and a few other aspects that aren't as directly pertinent to employers. And then what we're here to talk about today on March 27th, the CARES Act. So that's just kind of a little background. I think this is a good point to interject. For those who are following the news and keeping up on this issue, you're probably well aware that the funding for this Paycheck Protection Program has been exhausted. And yesterday, Congress failed to put in another package to fund that again. So unfortunately, I don't have a crystal ball. I don't know what's going to happen. I do know that both state and federal government are active. So it's certainly possible, and I would almost tend to expect that there will be more funds coming, but obviously that's getting into politics of it. So for those who are out there or who have customers and clients with small businesses who have not applied, then hopefully those funds will come. For those who've already applied, hopefully what we'll talk about will help understand how the funds can be used, what's proper and what's not. So, but as of today, as far as I understand, the funding has dried up for now. So what is paycheck protection? It's a small business loan, so it's not an entirely new creature. Congress used the Small Business Act. There's Section 7A guaranteed loans under the program that already existed, max of $10 million. The funds must be applied before June 30th. So it's really a short-term injection of cash to keep the business running. Now, whether that'll be sufficient amount of time, depending on what's going on in the economy, we don't know yet. It may not be, but at least that's where we are with the law at this point. There's no fees, no collateral or guarantees required, personal guarantees, so that's good, and no recourse against shareholders of the company, owners, etc. And I think the loan terms are good, but perhaps the best piece of it is of course, the forgiveness aspect. So if you follow the rules and do it right, most, if not all, of the loan principal is forgivable. So it becomes loan money that turns into free money. And how we do that, we'll talk about here in a bit. But the funds, again, must be used within 8 weeks if you want to get full repayment. The initial question, of course, is who qualifies. So it's generally businesses. And when we say businesses, we're talking about the usual suspects, LLCs, corporations, nonprofits are thrown in there, sole proprietors as well. Even independent contractors have the ability to take advantage of this. It's small business focused, of course, so that means that you've got to have 500 or fewer employees. That's the line that they set. It's also for business that have been in operation. Congress probably smartly didn't want businesses to be created to take advantage of this free or forgivable money. So you had to be a going concern on February 15th and compensating employees. If you don't have employees on payroll, which could be the case with some small businesses that are, the mom and pop variety, they don't qualify. And like I said, independent contractors are also included in the mix. Who makes the loans? Well, it's any lender that already provides SBA loans. So for most businesses, the answer, where do I go? The answer to that question is talk to your lender. Your bank probably does it if you have a line of credit or some kind of a business relationship with a commercial arm of a banking institution. They have to opt in, but that's where I would start. It's fairly broad in that sense. The lenders do have some incentive, and just sort of anecdotally, I did hear from a small business here in Washington. It's a kind of a plumbing-oriented business, and they were able to run through the process in a couple of weeks. I don't know if they funded, but it did go pretty quickly. So I don't know if that's entirely due to the fact that there's something in it to help the lenders, but there are incentives for lenders to make these loans available. In terms of the application process, how do you apply? Well, you could start April 3rd, so we're a couple weeks in, and obviously we know from the funding drying up for now that a lot of businesses are taking advantage of that. I didn't get the current stats on where we are, but I think it was over 1 million, maybe 1.6 million in applications that have already got out. So for you folks, you may be in the process of applying. You may have customers who are in the process or but trying to see that through, and then others may still be applying depending on what Congress decides to do. Last Friday, the independent contractor applications became available, and the process isn't overly complicated. There's a form, and I'll give you the link in the slides here to where you can find the application. You've got to make some certifications as you would expect as a borrower, including that the payments have to be used to retain workers and maintain payroll. And we'll talk about this in a little bit, but the focus of the money is to protect the workers. That's the idea. So that's the general theory of what Congress was trying to do. Taking this money and paying off your mortgage is going to be problematic, and it's certainly not going to be forgivable. But like I said, the application is on the Treasury Department website. Here's a link to it, and I'm happy to make these slides available after the fact if anyone would like to get a copy of them. How much can you borrow? Well, there's a little formula. 10 million is the top side, but it's also capped at 2.5 times the borrower's average total monthly payments for payroll costs, as those are defined in the Act during 2019. And then I'm not going to really get into it, but if you have an economic injury disaster loan, which is a separate loan, that also affects the calculation. And so at this point, it's a good time to interject, where many of you have probably heard the joke about lawyers going to law school because they're not good at math. And so I think I'm okay, I guess, helping my grade school kids, but I'm not going to do live math calculations for you today. But I do want you to at least understand the concepts and know what the formula is and where you can find that. But the lesson is talk to your accountant. You're going to need to get them involved and make sure you're understanding how to satisfy these ratios based on what the regulations and the law requires. The next question is, if you get the money, great, how can you use it? So you've kind of got through all of those hurdles. How can you use the funds? Primarily, it's for eligible payroll costs. and they define those in the Act. It also covers healthcare related costs, group health benefits, even insurance premiums that go with that. So that's part of it. Rent is included, utility payments, the usual, power, water, transportation, etc., and mortgage interest payments and interest on other debts. So you can use it for your interest payments, but to just take the funds and pay off an entire mortgage, that's going to be problematic. But there's quite a broad array of appropriate uses of the funds. You just have to check the Act and make sure that you're using it appropriately. And this is where I echo what Steve said. This is, of course, information. I don't know everyone's specific situation, and a lot of these decisions are case by case. And so if you or a customer are indeed trying to either get an application or work through different aspects of what's the proper way to use a loan, I do encourage you to consult with your employment counsel. It's very important. And with that, have your accountants on hand to work with that as well. Here's the kicker, and you've maybe heard this 75% figure, but at least 75% of the proceeds must be used for payroll costs if you want it to be forgivable. So that's not true. If you're using the funds properly and you use less than 75% for payroll, that's fine. You end up with a loan you have to repay on really good terms, which we can talk about. But if you want to get the forgiveness, which of course, anytime, and certainly in this economic environment you do, you have to pay attention to that 75% calculation. At least 75% has to go to payroll costs if you want to receive the forgiveness. In terms of what a payroll cost is, the Act defines it as what you would expect generally, I think. So salaries, wages, and commissions, cash tips and equivalent are included in there. Also something that you might not have thought, vacation pay, parental, family, and medical sick leave pay, that's included. And one that might be surprising is even separation payments. So if you're giving severance to employees because you can no longer afford to keep them on during this time, those payments are actually included in what's a proper use of funds. Also, like I mentioned, group health care benefits and premiums, retirement benefits are included, local and state taxes are included. So again, there's a large variety of appropriate uses for the funds. You just want to make sure that you're within one of those categories. Oh, looks like did I back up here? Oh, pardon me. Okay, I guess we'll continue. Got to get used to my slides here. Here's what it doesn't include. So this is important to pay attention to. Eligible payroll costs are not costs above an annual salary of $100,000. So if you have folks who are making in excess of $100,000, the annualized portion that's above $100,000 is not a proper use of those funds. So again, the idea is to help the worker and to help the workers, particularly who are making less than $100,000. That was just an arbitrary line that Congress drew in this Emergency Act. It also doesn't include amounts paid to independent contractors. So there's a distinction to note. If you are an independent contractor, it's possible to apply for the loan and get loan funds, but payments to independent contractors do not apply for your business. The idea there that the funds should go to your employees, and that's just where Congress drew the line. It doesn't apply if you've got people working overseas. Don't know how much that would apply to you or your customers, but that's another rule. It doesn't apply for FFCRA costs. That's the Federal Family Health Care Act. That's the qualified sick leave under the other act that I mentioned in the opening slides. The idea here is there is forgiveness available if you provide that emergency paid sick leave and emergency FMLA leave, because someone has to be out for one of there are 6 reasons listed in that particular law, this new emergency law, and they don't want you double dipping. So you can't get a tax credit and also get funds for what's paid out. So that makes sense, but that's just something to be aware of. So point being, no double dipping. In terms of other things to be aware of and just exercising caution and how you use the funds, this is not a huge point, but just understand there may be consequences. The SBA under the Act has the ability to take action against improper uses of the funds, and that can even include against shareholders, members, and partners of the business. So if you get the funds, again, work with counsel, work with your accountant to make sure that you are using the funds appropriately and you've got a good paper trail to prove that, so that you don't get in hot water. One of the realities of this pandemic, besides the awful human toll, the healthcare system, and all of that piece, in terms of the economics of it, is I think we're going to see, unfortunately, a lot of litigation coming out against employers for actions taken during the pandemic. We've already seen an onslaught of whistleblower cases or whistleblower claims with OSHA for employees saying they weren't properly kept safe from the coronavirus. And I anticipate that employment plaintiff attorneys, I'm defense, I represent companies, but the plaintiff attorneys are going to be looking for all kinds of avenues to find fault in what employers have done. And so it's important to be careful and understand. And the reality is it's difficult because in a lot of cases, we don't always know exactly where the lines are. For the most part with CARES we do, but in some of the other laws that are coming out, it's not always entirely clear. And you really have to make those risk assessments with counsel that are appropriate for your business. So there are penalties there. That's the scary slide. But you're here, and anyone who's watching this later is here to get the information so they do it right. So we talked about the proper use of funds, what you can use the money for, but the bigger issue for most businesses is, of course, going to be how do we get that forgiven? So what amounts can be forgiven? Well, it's certain costs during the 8-week period following the origination date of the loan. So when the loan originates, and it's payroll costs, but again, you've got to keep it at 75% in order to achieve forgiveness. The other things are true as well. The rent obligations, the utility payments, interest on mortgage and other obligations for debt, and even the loan principal amount is forgivable. So that's what you have to keep in mind. The forgiveness is really focused on this 8-week period. You can use funds for other appropriate purposes like I've talked about, but if it's not within this 8-week period and if it's not satisfying this criteria that I'm showing you now, then it is likely not going to be forgivable, and you'll just have to repay it under, like I said, generous terms. Just be aware that debt forgiveness is treated different than federal tax income, and that's where I'd say talk to your accountant, talk to your tax attorney. That's just one of the small points to note about the Act. In terms of loan forgiveness and possible reductions, one question is, if a business accepts funds, is it prohibited from reducing employee salaries or laying off employees? So in other words, you've got the money. Does that mean now your hands are tied and you can't lay folks off if that's what your business needs dictate? No, the answer is no. You can still utilize the loan and lay off employees or reduce employee salaries. What this does, though, is it impacts the amount of the loan that's forgivable. Obviously, if you don't have folks on salary, then into the calculation, you have less that's forgivable in that 8-week period. And the forgiveness has been made contingent on whether the number of employees has been reduced recently or was reduced during the 8-week loan period. So your hands are not tied, but it may affect what amount is forgiven. And so that's just something to keep in mind. But if you're a business that you've received the funds and you also talk to your CFO, or you're the CFO, and you realize you've got to make some tough decisions about layoffs, you still have the ability to do that. In the same token, a decrease during the 8-week period in your FTE employees reduces the potential forgiveness amount. One interesting note is, and this is, I'm talking about a formula. I'm talking about a time where you involve your accountant or those who are, whizzes with the numbers, but it will affect your calculation. But you do have the ability, if you do have to lay people off, you can rehire them by June 30th and avoid the reduction based on that formula in the amount that's forgiven. So that's good. The incentive there is that if you have to lay off, even temporarily, if you hire them back, there's more forgiveness available for the employer. Again, the focus here just to keep working with, keep employees working. That's what Congress is ultimately focused on here. In terms of what the calculation looks like here, oops. There we go. There's just a slide that kind of runs through the formula. And like I said, I'm not going to get deep into that here, but when you have the slides, this is kind of a good graphic to see what the calculation looks like. You can see at the bottom here, there are basically two ways to calculate it, based on the average number of FTEs per month employed from February 15th to June 30th, or there's a separate calculation based on average number of employees per month from January to February 29th. So basically, Congress had to come up with some way to calculate the forgiveness, and they just created a formula. They just made it up, and that's the formula that applies and that you'll need to utilize when you're looking for forgiveness. Like I said before, talk to your accountant. These are issues that you need to be very much in sync with your accountant about, and understanding your books and your balance sheet and income statements. That kind of walks you through the basics. How do you apply? Go to the Treasury Department, get an application, work through your usual SBA lender. You know how to use the funds. You know what is a forgivable use of the fund versus what's just a proper use of the fund. And there's a lot of overlap there that you probably noticed. The next question is, how do you get forgiveness? You want to get out of this. You want the free money, of course. That's the end game, I think, for most employers here. You actually go back to your lender. So the way the Act is designed is that the lender is the vehicle through which you seek the forgiveness. I don't think we know a lot about what that's going to look like. Obviously, talk to your lender. I'm sure lenders and their counsel are scrambling to figure out what this is going to look like and create processes for this, just like a lot of organizations are doing right now. I mean, for example, employment security here in Washington, there have been a number of emergency measures, and employment security has had to make some on-the-fly quick changes. So what we do know, you need to document and verify the number of employees on payroll. You need their pay rate, so just basic payroll information, IRS payroll, tax filings, and state income. You will also need to document your payroll and unemployment insurance filings. That's part of what's required. You need, as we know now, we've covered it, mortgage obligations and lease obligations and utilities are also proper uses of the funds and forgivable uses. So you've got to document those. So keep track of the paperwork that relates to that. And then, so the lesson is really just keep all the paperwork, make sure you have the documentation, and then talk to your lender. There's really not much more guidance about how to do that. So just what you really need to do is build your case. You need to know that you've dotted all your I's and crossed all your T's. You have everything in order in terms of the documentation that you would submit to your lender. Exactly how that process is going to look, I don't think we know yet. Lenders are working that out, but that's the key take home. Document. In addition to the documentation, to get the forgiveness, you will need a certification from an authorized representative that says, essentially under penalty of perjury, that the amount being forgiven was used per the program guidelines. Now, if you're going to make that certification, that's a great time to talk with counsel. Pull all the documents together, work with counsel, look at the numbers, get into the detail, and feel confident that, yes, I can make this certification, because you don't want to end up on the wrong side of that and have to deal with those potential penalties and consequences that I was talking about earlier. In terms of repayment of unforgiven amounts. So there are proper uses that are not forgivable. It's not free money, it's loan money. What happens then if you have a portion or potentially all of the funds that are not forgiven or not forgivable? What happens then? Well, you've got a 2-year loan. It's capped out at a 1% interest rate. So it's a good rate. There's no prepayment penalty. And on top of that, Congress decided to give you an automatic repayment deferral. So you have 6 months before the first payment is made. So it wouldn't be till the 7th month when you have to begin repaying any unforgiven amounts of the loan on the 1% rate. And it's annual, or it's amortized. There's the word. It's amortized over the 18-month period after that 6-month deferral. So if you're looking to calculate the number of what that payment would look like, that's how you do that. Of course, the lesson is act now. Hopefully, many of you or your customers are already in the application process. It's a first come, first served process. There is a limit on the loans, so obviously you want to do that. Again, there's the application information there. And then stay tuned. In terms of other funding, we don't know what's going to happen, but we know that the coronavirus has got the attention of federal, state, and local governments, and they're taking a lot of measures that are very unusual. This particular act, the Paycheck Protection Program, is one of them. It's probably reasonable to expect additional measures to help employers and employees, and hopefully one of those is to replenish the funds available. But when that happens, if and when it happens, the advice is get on it, because it's going to dry up again. I'm quite certain of that. Just before we get to questions, I think we've kind of covered all the aspects, but I do want to just make sure you've got some resources here. You could certainly reach out to me and our firm as well. We do have a COVID-19 news website, so there's information there about the FFCRA, the expanded FMLA, and paid sick leave provisions that were enacted by Congress. In Washington, where we are, there's unemployment changes that have happened, and so those are all documented there. And I always welcome questions. Feel free to ping me if you have a follow-up question or even want to talk about a possible consultation. There's my information. And then I've also included some other resources. And again, focus on the CARES Act, but also just other issues that are going out there. The Department of Labor website, almost without exception now, if you go to a state or federal government website, the first page you're greeted with is something about the coronavirus. In my world, dealing with a lot of litigation, that's court websites too, and they're either closed or severely limited. And so, but there's some good information about those kind of pieces. And also at the Treasury Department and the IRS, there's information there. So I included some of the links to kind of help guide folks. And I think with that, I've covered everything. I'm happy to take questions, and I may lean on Steve or potentially Ian to help.
Yeah, absolutely. Josh, thanks for doing this. I'll just say, if
Sure.
you have questions, or some have come in already, so I'll get to those in a second here. It's allowing folks to maybe add a question or two. We have recorded this, and as long as I haven't done something wrong on my end, we plan on posting this to our YouTube channel, and we'll probably put it up for a time. And if it gets to a point where, to Josh's point, things are changing and whatnot, if it gets to a point where this information is outdated, we can pull it down. But we're gonna put that up on our YouTube channel. And then the slides, Josh, you've mentioned you're happy to share those, and we can facilitate that. So we'll share that out to everyone that's registered
Perfect.
To the webinar. With that, I'm going to get to the questions here. I'm just going to kind of take them as they come.
Great.
Let's see here. First question. Can you get, and you mentioned it, I don't know what the acronym stands for, you mentioned it, but can you get an EIDL grant and a PPP loan?
You can. And what happens if you do get an EIDL grant, that's a separate program that I referenced briefly. What happens is if you get the grant, and I believe it's capped, I think it's a $10,000 grant, memory serves, then you subsequently get the SBA loan under the CARES Act. It just has to be wrapped into that loan. and the same forgiveness principles apply. So that's kind of how that process works. So there is ability. The idea with the EIDLs is that it was money. I think it was supposed to be available in 3 days, so it's really fast money, but not as much. Capped at, I believe it's 10,000. I should check my notes, but so that's kind of the interaction there with that.
Very good. And this might lead into, in color, the next question. When the program was initially introduced, I thought I understood that up to 10,000 would be forgiven. Based on what you're saying today, the full loan amount can be forgiven if funds are used properly.
That's correct. Yep. And I should clarify. There's a couple of the EIDL question. That there are emergency economic injury grants that are up to $10,000. There was also an economic injury disaster loan program. Those provide working capital of up to $2 million from the SBA. So there's a couple of different programs that are out there, and there's some good guidance on that. I believe it's the Treasury website, or either that or the Small Business. It's one of the links that I provided that has kind of a fact sheet that walks through the comparison of how those relate to each other. So I want to just be clear, the 10,000 relates to the economic injury grants. But yes, in terms of forgiveness, if we're talking about the paycheck protection loans, it can all be forgivable if you use it for a forgivable purpose in that 8-week period from origination.
Great. Next question, there's a couple more, so if you have any, please send those in. We got maybe 2 or 3 more to go. Next one.
Sure.
Is there an SBA product now or lending options for new businesses starting in this COVID-19 environment with a portion of the debt forgiveness if you're employing people in Oregon or Washington?
Not that I'm aware of. Of course, like we talked about, you have to be in business in February 15th to be eligible for the paycheck protection. So if you consider new because you started at the beginning of the year, then the answer is yes. But if you just in the last few weeks or since February 15th started the business, no, you're not going to qualify. And I think for good reason. Someone doing that may have pure intentions, but there are folks who would create a business, maybe a shell business, to take advantage of funds, inappropriately. So I think that's the theory in that rule. So depending on how you define new, you can get the funding. It just depends on that February 15th date.
Great. And it looks like a couple more questions are still coming in. That's great. Next question: are
Sure.
we allowed to increase employee salaries?
There's no limitation that I'm aware of on increasing employee salaries. There is a limitation on going above the $100,000 threshold on an annualized basis. So if you had folks at 95 and you wanted to bump them to 105 on an annualized basis, the portion above $100,000, the 5, would not be forgivable, nor would it be a proper use of those funds. And so this is where you've got to have your accountant involved. But as I'm aware, there's not a restriction on changing the amounts that are paid. I would, if you're thinking about doing that, if you're thinking about making any changes to how payroll operates, I would encourage you to consult with counsel to make sure you can get an individualized risk assessment for your business. Because one of the pieces is we only know what we know, which is the rules in an emergency act, and there are inevitable gray areas, and that could be one where you might say, well, by the letter of the law, we're okay, but we need to calculate the possible risk that this could become a problem down the line. So there's no limitation, but I would consult with counsel if that's the decision you're going to make, or if you're thinking about that.
Okay, very good. And then you may have addressed this, I'm not sure. Can a person who receives 1099, an independent agent, so a lot of our folks on the calls, are agents, and many of them
Yep.
are 1099.
Sure.
Can you still apply and get this loan?
Yes. They're independent contractors, often referred to as 1099s, are eligible. The loan availability started a week later. So instead of February 3rd when the loan process opened up, it was last Friday, February 10th. The distinction to just keep in mind is if you are the independent contractor, you have the ability to apply for these loan proceeds. If you are an employer who is paying an independent contractor, the payment to an independent contractor is not a proper use. It's got to be a payroll cost to your, for the, probably the more common term would be to your W-2 employees, not to an independent contractor. So that's the distinction to keep in mind. But if you are an independent contractor, then you do have the ability to apply.
Okay, very good, very good. And it looks like questions are still coming. That's great. Next one here, can you still get a loan if your business is running normal, all employees are still working?
Yeah, yes, absolutely. I mean, that's really the theory of it. If your business is operating and you're using the funds for payroll purposes. So I think the answer is yes to that. I'm not aware of any restrictions on that, as long as you're using the funds for the purposes that are provided.
And I'm going to maybe add to the question, just as I'm inferring what they might be driving at. If the business is operating normally and the revenues are normal, would you still qualify for the loan? Maybe that's the spin I put on the question.
Oh, I see. That's one that you'd have to look at the application. I'm not sure we have all of the information on whether you would be granted, approved for a loan. It would have to come into the application. So I hesitate to make a blanket statement in response to that. I would consult with counsel, and I would also consult with the lender. I mean, I think it will come into my expectation is that it would come into whether you would be approved for the loan and the certifications that go into that process. Because it is true, the money is intended for those who are struggling to meet payroll needs. But you're kind of in one of those areas where it's a gray, and you need to think carefully about it. So what the answer may be, you just aren't approved for the loan, but you still should consult with counsel to make sure you're navigating that appropriately, because like I mentioned, there are the penalties. So, but that's one you take on a case-by-case basis. And also pat yourself on the back if you are operating just as profitably now as you were during pre-pandemic, because that's not the case in most of the businesses that I'm dealing with. So,
right. Next question. Should I assume that we will not receive PPP even if our application was submitted last week? And this might be the crystal ball question, but
yeah, I don't know where the trickle of money is, to be honest. I'm not entirely certain. If at what phase in the process you have to be. I would anticipate it's probably loan origination. That's my understanding, but I don't know for sure. And there may be some reporting issues from all the different lenders. So I don't know, no crystal ball. I would talk to your lender. I would work with your lender and ask them. And certainly if you have an application in process, I would keep pushing forward until your lender says otherwise.
Okay, very good. Next question is a great question. Might be a detailed situational question, so I'm going to preface it that way. I did not lay off my employees. I kept paying them even when my doors were closed. Employees worked, but no sales. Now I hear the forgiveness of money is for the 8 weeks after the funding is given. The question is why? I held the doors open, did not close them, and I understood the payroll would be covered during this time.
Sure. Why indeed? Well, I mean, so from the perspective of Congress, I think they're in a battle, they're in an emergency situation, and they put together a program the best that they could negotiate amongst the various parties. And so that's just the arbitrary line that they drew. Is it fair or right or proper? I don't know. You can argue it's not, but that's the way, you know, they had to draw a line somewhere, and sometimes you just have to make a clear line in the sand, and so that's just what they've done. Certainly going forward, you would still have the ability to seek forgiveness for those costs in the ensuing 8-week period of payroll from origination, obviously assuming that there's additional funding that's provided. So I guess that's sort of a question for your congressman or woman. It just sort of, it's the way it came out. It's not shocking, because they had to just make some quick decisions and come up with some simple rules to make the program manageable so that lenders can understand it and businesses can know what they're up against. But yeah, is it entirely fair? Maybe not.
This will be the last question, unless some come in as you're answering it. You know, can
Okay.
I use it? Can I use it? I'm assuming that's the PPP on exclusive 1099 sales producers in my agency. And I think you may have touched on this already, but no, that's not a proper use. So that's what I was getting to. If you're paying 1099s, independent contractors, otherwise known as, then those are not proper uses. Those 1099s could potentially apply for a loan and forgiveness of that loan themselves, but the act, in terms of the proper use of the fund, says that it applies to W-2, just for lack of a better term, W-2 employees. Very good, very good. Well, that concludes all the questions. Joshua, Brittingham, everybody, if I could give you a round of applause, we'd probably all do that. Thank you for doing this.
I can hear it. I can feel it.
Good. For those on the phone, I hope this was helpful. You know, as I stated at the outset, that's what we want to do here. We want to help you through this and understand it's a challenging time. And if we can help you, please call us. If you need to talk to someone, please call us. So we understand that we're all probably talking to the walls a little bit as well. So I hope you all hang in there. Thank you so much for everyone that participated. Joshua, thank you. I'll give you a call maybe after this just to wrap up. But really appreciate your time and expertise.
Absolutely, my pleasure, and I wish you all the best. Stay healthy.
All right, thank you. You too.